Congratulate my colleague Darian Fenton on outlining very, very clearly some, and I would say only some, of the major pitfalls and the major clawbacks, because that's when we negotiate in workplaces, that's what these clauses are commonly known as. And if we look, Mr. Chair, these are clauses, these are conditions, these are rights that actually Labor in government reinstated. Labor in government reinstated to hold with the principle that that ACC should be a no-faults system, a social contract when people are injured. And that, Mr. Chair, is something that all New Zealanders have felt very, very proud of. It is something that has worked. It is something that is not broken. Despite the ministers, and I note that Pansy Wong is in the chair, and I haven't heard Pansy Wong speak on this before, and I actually think that she should take a call on this. Nick Smith's contribution yesterday is probably why we're not hearing that contribution now, was absolutely appalling. It was offensive. It was offensive to many people. Certainly all people on this side of the House, and I would urge the Māori Party, because I want to congratulate obviously the Labour opposition, but also the Green Party, who have consistently opposed this bill on the basis that it is simply unfair. It is simply taking away rights from New Zealanders, and that is not the principle. That is the absolute opposition to what the principle of what ACC is about. So I want to congratulate the Green Party, but I want to challenge the Māori Party, because it's not too late. It's not too late to change your mind, to change their mind, because it is inappropriate to support many of the clauses in this bill. So in terms of, I would urge and hope they would take a call. Yes. And that's excellent. That's excellent. Okay.
So innocent.
But in terms of the first progress to select committee, the Māori Party selected it, and if the Māori supported it to select committee, and perhaps if the opposition had happened there, the bill wouldn't be back before the House now. In terms of, and I have talked about this before, but I think it's very important, because the ministers claim that ACC is broke. How many times have we heard the minister say, Minister Nick Smith, ACC is broke? Well, ACC isn't broke. $11 billion in reserves does not mean that ACC is broke. In fact, quite the opposite. So in terms of, if we look at independent advice, that PricewaterhouseCoopers from Australia, they found that the administration costs are lower than any other scheme. That confirmed previous assessments, but this is a very, very pertinent point. ACC, that is seen and has been criticised by the national government, has been assessed as the most cost-effective in terms of administration. So this is simply because of the simplicity of the scheme. It is simply a no-fault structure. It covers injuries at work or elsewhere, with a broad pool of levies coming in. So I would urge the government to reconsider their position, that certainly that ACC levies do not need to rise, and the only reason we can perceive that levies would rise is because there is an agenda. And what could that agenda be? What could that agenda be under a national government? Two guesses, says Marion Street. I don't think we need two guesses. I think we only need one guess. And I think that is privatisation. That is ultimately what will be at the end of this. We saw, as I've spoken on before, absolute slashes to conditions under ACC in the last government when we saw the slashing of lump sum payments, and this is very much going along the same scenario. I want to talk about hearing loss, Mr Chair, if I can talk about that. And I know a number of my colleagues have spoken about it. Mr Chair, Mr Chair, Mr Chair.
Call in polite.
Thank you, Mr Chair. That in terms of hearing loss, that the imposing now of a bar of when hearing loss, where people will get work-related. It's all right, exactly. As Ruth Dyson says, it is all right to be a little bit injured. And that never mind that if a professional says, now we already have, there is a bar in terms of age, in terms of eligibility for hearing aids, but what this government is saying is despite that somebody who has hearing impairment, that is work-related, that is no fault of their own, that despite that they have to, if it's just a little bit, despite the fact that their quality of life, and I know that members of Labour will attest that at the Select Committee there were some very compelling submissions about hearing loss. Am I correct on that? And that despite that, this lousy government is saying that it is unacceptable and that anything less than 6% hearing loss, foot the bill yourself. Okay? The principle is no faults, but what this government is saying, if it's just a little bit, or what we perceive as a little bit, never mind what professionals say, never mind what the Deaf Association says, if that is that the government's view is that's enough, that we don't have to fund it, that funding will be put onto the person who, as I said before, through no fault of their own has suffered hearing loss. Now, what is this going to do? What alternative do people have in that situation? They either foot the bill or they think this simply isn't fair and they will pursue or look at if they can sue, in many cases, their employer. Now, what is the principle of ACC? We go back to basic principles. It is a no-fault system. So that, Mr Chair, is absolutely a silly, and the minimal amount that will be saved will be absolutely minimal, but what it will do is cause considerable stress, anxiety and financial stress to people who have suffered a work-related injury. So that, Mr Speaker, we are absolutely opposed to, as indeed we are with many of the other clauses. Clause 53, work-related gradual process. Now, we know that will affect older people. But also at the moment we are hearing, and I think many of my colleagues will confirm this, we are hearing from many people at the moment who are saying we are being told that our claim is gradual process and that we have to, the stress, so we are not getting any support from ACC and we have to go through this long process of challenging, of going to review, etc., etc. Now, whilst many people go to review, which has obviously, without the support from ACC, causes considerable financial strain, and we know how long they are waiting for their review and having their ability to see justice served. As well as that, there is then going through that process, then that decision may be upheld. But the other thing that concerns me, Mr Chair, is the people that don't go through that process. The people who see that the stress and anxiety with all of this is too hard and they just drop it. They just box on not getting this financial support that they probably are entitled to, but because of ACC's cost-cutting agenda that is nothing short of ruthless, and I'm pleased to see the Minister of Labour in the chair, because the next thing I want to talk about is holiday pay. Holiday pay. Oh yes, use up your holiday pay. Now this Minister of Labour is not familiar with many issues to do with labour. I think even she will accept that. I think I see her nodding. Well look, the situation is that holiday pay is not double dipping. It is not double dipping. Holiday pay is a right that has been accrued by work. People have worked and they have accrued that right to holiday pay. I've got news for the Minister and the government that when you are injured, you are not on holiday. It is not a holiday. And if the government went out and spoke to